My name is Arran Dowling Hussey. I'm a barrister and arbitrator practicing in the Law Library in Dublin, and I'm a member of the committee of the Chartered Institute of Arbitrators in Dublin. And I'm going to make some remarks about arbitration. Colleagues of mine have made similar remarks about other areas within alternate dispute resolution, and you can look at them in relation to processes such as adjudication and mediation. Arbitration is the alternate dispute resolution process that is most similar to the traditional court-based resolution of disputes that most people will be familiar with from TV shows and movies. The main advantage of arbitration is that it's private. It's, when it works well, quicker than litigation, and it's possible to choose your own judge. So with arbitration, you can have a bespoke process where you choose your own judge, and you can run it under an expedited process whereby it might have to be concluded within, say, 100 days. So it used to be the case that under the previous legislation that existed before June 2010, that an arbitration could be dragged out by the parties running to court. So the parties would find some reason to appeal what had happened to the High Court, and then there would be an appeal to the Supreme Court. And at that time, when there was no Court of Appeal, you saw the classic example, such as in the Samuel Kingston case, where the gap in time between Mr. Justice O'Donnell of the Supreme Court's decision on the Samuel Kingston case relating to a construction project in Eyre Square, where the arbitrator who heard the dispute was said to have misconducted himself. The gap in time between the project and the Supreme Court decision on the bona fides of how the arbitration was conducted was something in the order of 5 years. So the new legislation, if I may still call it that, and some people are still unfamiliar with it, the new legislation stops you running off to court as often as you could to try and undermine an arbitration, and you're not allowed to appeal what the High Court judge may say about the arbitration to the Court of Appeal. So the courts now have a very defensive position in terms of arbitration. Arbitration is an adjunct to traditional litigation. It's never going to replace litigation, but if you want, for reasons of commercial sensitivity, to have a process similar to a court case, but in private, where you pick the judge and it can be done at a breakneck speed, arbitration is something that I'd commend to you. So it can be used in many instances. At the time I'm talking to you now, there's recently been an application by an athlete to the High Court trying to compel her governing body to pick her for international competition. And there used to be an awful lot of those cases. And if you're a governing body with a limited budget, it's terribly expensive for you. And that's why bodies which members of the Chartered Institute of Arbitrators work within as arbitrators, such as Just Sport Ireland or the Dispute Resolution Authority, have greatly assisted the resolution of sports disputes. Closer to home, there are a number of well-known arbitral schemes that the Chartered Institute of Arbitrators has honed and cultivated over the years, where they seek to allow people who've had a bad experience in relation to purchasing a car or going on holiday to resolve those differences by way of arbitral schemes administered by the CIARB. And as a general guide, those disputes are resolved within around 6 months from when the arbitrator is appointed by the CIARB, which is much quicker than the equivalent timescale that a court would take to resolve the dispute. So the Chartered Institute of Arbitrators runs courses and runs regular networking events where people who have an interest in arbitration can upskill and meet other colleagues in a social environment and share the problems they might have. And there's a range of pathway courses that allow people to go from being an associate to a member, to a fellow, to a chartered arbitrator, which is the highest rank within the range of qualifications that the Chartered Institute give to arbitrators.